In Scotland, we have specific legislation relating to what happens if a couple separate who have been cohabiting. There are rights in terms of the cohabitation laws that covers money, household goods, belongings, joint accounts and savings. There is also rights and claims that can be made if, unfortunately, one of the cohabitees dies. The legislation is limited in that it was framed in such a way as the financial claims that can be made by a couple who are separating after cohabiting is not the same as a couple who are married or who are civil partners. This is an extremely difficult area of the law to navigate because of the way that the rights and claims are framed within the legislation. The position is that early advice is required in most cases in relation to such matters. The type of financial claim that can be made are limited under cohabitation laws, and that's for a capital sum of a specific amount or the future economic burden of caring for a child. The legislation does not allow a party to seek a transfer of a jointly owned property. The remedy in relation to same is only seeking a sale, but that is not under cohabitation laws. It becomes more complicated when you are looking at financial provision because what we are considering here is contributions. And it is about balancing up those contributions and to see whether there's any imbalance at the end of the relationship. This is a complicated area of law and early advice should always be sought. The issues the court has to consider is whether one party has derived an economic advantage or suffered an economic disadvantage. This can involve a detailed analysis and consideration of contributions. It is not an easy issue to manoeuvre, and there can be a lot of financial information required. The area is further complicated in that there is little case law because of the manner in which there is so much discretion afforded to the courts. It is therefore always beneficial to seek advice, as this is a complicated and complex area of law. There are very strict time limits for making a claim for financial provision when cohabitation is ended. In relation to a couple who are separating, it is 1 year from the date upon which the cohabitation ended. In relation to one of the cohabitees dying, that requires to be made within 6 months. In relation to cohabitation, which ends in death, the survivor can make a claim only if their partner has died without leaving a will, which is called intestacy. It is very important for couples who are considering living together to perhaps consider a cohabitation agreement. In Scotland, you can contract and agree in writing any formal arrangements. The cohabitation legislation does not specifically mention agreements, but what is important here is that you can avoid disputes if you enter into an agreement which parties have agreed what is to happen in certain circumstances. A well-drafted agreement can provide security, it can provide protection, it can provide certainty, and ultimately avoid any disputes. For example, if a couple are considering cohabiting, sometimes they might want to regulate who is paying household bills, what is happening in regard to repairs. Also, if someone is making a significant contribution to a deposit to purchase a house, that can be important to try and identify that within a written agreement or ring fence it. There are lots of matters that couples would want to include especially in relation to a heritable property. It can be important to regulate what is to happen to that property in the event of a separation. The current legislation does not allow a transfer of a property, so that is one matter that can be agreed and dealt with within a written agreement between the parties that may avoid upset, distress and uncertainty at a later date. That was a very brief overview of cohabitation. If you have any queries in relation to cohabitation at all, you should not hesitate to contact me or anyone at Waitmans, including my colleagues in the Scottish Family team.